Hello, and welcome to this session of the training for helping conscientious objectors. And my name is Bill Galvin. I work at the Center on Conscience and War in Washington, D.C. And we were founded back in 1940 to support conscientious objectors. If you have not seen the first session of this, which is more focused towards folks who are trying to be conscientious objectors, but it has a lot of information that would be important for you to know here. If you, okay, so it is important that anybody who is taking this training look also at what happened in our previous training, because at that point we covered a lot of detail about conscientious objection. We'll review it briefly in this session, but it'll be important to go to that session to get most of those details. But I work at the Center on Conscience and War, and our job is to help conscientious objectors. We've been at it for over 80 years now. Not me personally, but I've been at it for a long time myself. And it's just for us a real joy to, be able to work with and meet and get to know many wonderful people of conscience. Now, under U.S. law, there are basically three areas where conscientious objection is recognized. Okay, one of them is in the the main one, the one we're going to talk about today. Is in the draft law, and that is actually where the conscientious objection is most spelled out and has the most court cases helping to refine and define what that is. But there are two other areas also. One is in military regulations. The military has regulations based on the draft law that would provide for the discharge or the reclassification to non-combat duties to people who become conscientious objectors. And conscientious objectors, just to be clear, are people who believe it's wrong to participate in war. The main difference for those in the military who are applying for discharge, well, besides the fact they're in the military and in a kind of a often hostile environment, and the fact that it takes a long time, it's a more complicated process. But the main difference in terms of the requirement is that people in the military have to show how their beliefs crystallized, became firm and fixed and, a controlling force in their life once they joined the military. Because if they felt this before they joined, they wouldn't have joined. So that's an important difference for folks in the military. For people facing the draft, often showing childhood influences, growing up in a friend's meeting or going to church or something like that, where you were taught various things, is going to be helpful. But for people in the military, it's a bit different. The other area in U.S. law is in immigration law. Those of us that are citizens, were born here, may not be aware, but when people become citizens, they have to take an oath to the country, and part of that oath includes a promise to bear arms in defense of the country when called upon or when required by law or something like that. And there was actually a long struggle going back to the 1920s, as far as I know, but the biggest struggle was in the 1940s and 50s, and eventually immigration law did include a provision for conscientious objectors. And so conscientious objectors would be able to become citizens without making a pledge to bear arms for the country. They would still, could, if called, could be required to do alternative service or non-combatant service of some kind, but they would not be required to bear arms. So that is one of the other areas where conscientious objection is in U.S. law. But we are going to mostly be talking about the draft law today, and how to help conscientious objectors and others who are facing the draft know how to do that well. So that's a basic framework for the work that we do. Now, as counselors, it's important that first and foremost, we listen to the people that we're counseling. Okay, we listen to the conscientious objectors or others that come to us for help, and hear what they are saying and what they're concerned about, and respond to them, and help them best articulate their values and not impose our values on them. Okay, and that's going to be really, really important. I mean, I myself was a conscientious objector during the Vietnam War, and my objection was rooted in my Christian faith. I'm still a Christian. I still believe those things, but I work with conscientious objectors from all different kinds of faith traditions. Muslim and Jewish and Buddhist and Baha'i and Wiccan, as well as and others. But those are just some of the ones that come to mind, and also non-religious people, and including like libertarians. Um, Libertarians believe in something called the non-aggression principle, and it's almost like a religious belief for some of them, in terms of how passionate they believe in that. So we, so our job is to help the folks who come to us best articulate their values, and express the objection to war that they have, that is rooted in their values. If we convince them to say things because it's what we think, we're not really doing them a service, because part of the process involves, a draft board hearing where the draft board members are going to be asking them questions about their application. And if, they were mimicking things that we said, but it's not really coming from their heart and not rooted in where their values are, that can often come across as insincerity, and can undermine their CO application. So first and foremost, we need to be listening to the folks who are coming to us for help, and doing our best to help them articulate things in their own framework, based and rooted in their own values. I mean, conscientious objectors come in many, many different forms, as well, as I've certainly seen, and you will too, as you do this work. Let's see. So the legal framework for what we do, well, obviously the legal framework for everything in the US, at least in theory, is the Constitution. And laws are supposed to conform to the Constitution, and sometimes, they are found to be unconstitutional. Or sometimes court cases intervene there. But the selective service law that we're going to be talking about is a law passed by Congress, and it is in effect right now. The only part of the draft law that is not in effect right now is the actual authority to draft people. But aside from that, the entire system is in effect. And so the draft law is a law passed by Congress. And there is a link, by the way, to that law in your manual, the Draft Counselor's Manual, that I believe you all have. And I think it's like on one of the first pages of the manual, there's a link. So you could actually read the law if you wanted to. It's kind of boring, but you can. Then there's also regulations that govern how the selective service system would work. And regulations are basically made up by the agency. They were made up by Selective Service, and then they get pre-published in the Federal Register, and there is a period of public comment. And then they're supposed to consider these comments and then republish the regulations. And if they have not changed substantially, then they have the effect of law. So even though they're not the law, they have the effect of law, because what they're about is implementing the law. And so that's that's certainly one of the issues that we need to be aware of, is that we've got we've got the regulations and the law, and you've got links to both of them in your manual, so you could go read them if you wanted to. I think the regs are actually a bit more interesting than the law, but you'll find that neither one of them is all that interesting to read. But in addition to that, Selective Service has developed procedures manuals, okay? And they now have 2 procedures manuals, okay? One of them is called RIMS, and the other one is called RIPS. And let me explain why we have two procedures manuals. Back in the 1980s, when the draft registration started again, the mandate of selective service was to have uh, like many thousands of draftees in the military within 2 weeks after Congress authorized the draft and the whole system, began. And so they developed basically a system to get folks in the military in just 2 weeks. And that was developed in the 1980s. And then by the mid 90s, the Pentagon was reevaluating things. And of course, they had closed a lot of bases. There were a lot of bases that were closed in the 1980s. And they came to the realization that, well, we wouldn't have the facilities to train all these people. If suddenly the draft started and suddenly we had thousands and thousands of people coming in, we don't have the facilities to train them all. So they revised what their plan was, and selective service was told that you have 6 months to get us a lot of folks. And so there'll be a 6-month lead time during which the Pentagon can beef up its training facilities, but also there'll be a little bit advanced warning for people who might be drafted. So that seems like a better scenario all the way around. But here's the problem, okay? They never rescinded the earlier 2-week scenario manual. I mean, it's still there. I mean, they say they're not going to use it. And to the best of my knowledge, they're training their draft boards on the 6-month scenario, not the 2-week scenario. However, the regulations support the 2-week scenario. Okay, so they've had since the 90s to change their regulations to be consistent with the system they say they're going to use, and they haven't done it. And so for that reason, we feel it's important to understand both systems, because if they were to start the draft and were to go to the 6-month system, they would have to change the regulations. They could very easily go to the 2-week system, and people might find themselves in the military before they even had a chance to think about it, because that is supported by the regulations. And so it's important to understand both of them. And so the two systems, one is the RIMS, that's the 2-week system, and that stands for Registrant Information Management System. That's the old 2-week system. Now there's another manual called RIPS, and that stands for Registrant Integrated Processing System. Okay, so you've got these two different procedures manuals. In theory, the manuals comply with the regulations comply with the law, and the law is constitutional. Okay, there's a hierarchy there. Sometimes things are out of sync. Okay, but in theory, that's the way it's supposed to work. Then in addition to that legal framework, we've got court cases, because sometimes there are challenges to laws like this, to whether they're constitutional or not. Other times the challenge is whether the law is being properly implemented or interpreted in this case. So court cases could interject themselves at various points in that hierarchy. But that is the hierarchy of laws that we are dealing with and the framework that we're dealing with. So as I mentioned, selective service does exist. There is a national headquarters in Washington. Actually, it's in Arlington, Virginia, right across the river. They've got a data management center where they keep track of all the people who registered, which is out in the Chicago area. I think it's Palatine, Illinois, something like that. And then they've got and that's where they call it the Great Lakes Data Management Center. There's also regions. I think there's 3 regions, selective service regions around the country. There are state directors in every state. There's a few of them that are vacant right now, but for the most part, there is a state director in every state. And there are also draft boards that are established in every state, really. And actually the norm is in every county. Okay, the norm is at least 1 draft board per county. Now, in very rural areas, there can be an inter-county board, but that is the exception to the rule. Okay, and draft boards are basically volunteers from the community who've decided to volunteer and serve the community in this way. And most of the draft board members are veterans. Many of them are deciding to serve selective service out of their own patriotism. They support a militaristic framework of the world. Now, we do encourage people of conscience, who feel that they could be on a draft board. We would encourage you to consider that if that's something your conscience will allow you to do. I mean, it's not something that my conscience would allow me to do, but it would be really good to have folks on draft boards who understand and are somewhat sympathetic to the CO position to help counter the anti-CO bias that seems pretty prevalent throughout, much of our culture and much of the military and selective service system. Um, it is pretty clear to me from talking to folks in the headquarters that the people in the headquarters of selective service really want the system to be fair and really want conscientious objectors to be treated fairly. And draft boards are trained, which they weren't back during the Vietnam period. So presumably with some training, they're not going to, they're going to be acting a bit better than they did back then. But there's no certainty of that, okay? And we know people, and like I say, we've encouraged people to get on boards, and we know some Quakers and other peace activists who have been on boards and are on boards, and they report back to us, okay? And one of the things we've heard is that, in terms of a training for a CO, like this one particular case, where it was a simulated hearing for a conscientious objector, and the person really qualified, but they weren't your stereotypical conscientious objector. And this friend of CO's who was on the draft board said that, it took him and the trainer from selective service much energy to convince the other members of the draft board that this person qualified. So under a normal scenario where you didn't have somebody from selective service trying to convince these board members that this person really did qualify, even though they didn't meet the stereotype, there's a good chance that person would have been turned down. So we do feel that there's probably still going to be problems. And of course, if there are appeals processes, and the further up you go with the appeals, presumably the better educated and informed folks are going to be about the right thing to do. But just be aware that there will probably be some problems that conscientious objectors encounter if the system ever gets activated and implemented. So as I said, I would encourage you to consider it. The basic requirements are: you have to be a U.S. citizen, you have to be a resident of the area over which the board has jurisdiction, and I think you have to be between the ages of 18 and 80, I believe. And you have to be registered for the draft if you're required to register for the draft. That is one of the requirements. And you have to be willing to administer the law. I think the wording is uniformly and fairly. So if those are things you feel you could do, conscientious objectors going before the board you would be on would be, would have a benefit from having somebody like you on the board. So I would encourage you to consider that if that is something your conscience will allow you to do. You could go to the Selective Service website for an application to join a board. And the Selective Service website is sss.gov. Okay, sss.gov. And once you get on there, you can, there's a number of things that are accessible on that website. Among them would be, the ability to register online if you choose to do that. You can verify your registration and get your registration number if you've registered. You can apply to be on a draft board. See some of the news coming out from selective service, which is, but things like that. Okay, so there will be, I mean, the draft boards are named. I don't know if the appeal boards have been named or not, but I know that there are draft boards throughout the country. There are vacancies on draft boards. So, you could apply if that was something that, moves you. Um, there will be area offices. Okay, although there will be local boards in every local board will not have an office, but there will be area offices that provide administrative support for several local boards. The exact number and how that's going to play out is actually currently being discussed by Selective Service. I think they want to. I think they want to have fewer of these offices, so then each office would then have to service more draft boards. Uh, but but typically when people are applying for a deferment or exemption or conscientious objector status, they're going to submit their data to the area office, and then the area office would get it to the correct local board. That's how it's set up to work. But the system is in place. You've got the national office, the data management center, you've got regions, and you've got local boards. We know all of that is in place. There are lots of reservists and or National Guard personnel that their job in the reserve is to be an administrative support for Selective Service. And so there are folks like that who are helping to train draft board members, and in some cases doing outreach to try to encourage people to register and just do other things in general to help the Selective Service system run efficiently. So that's the framework that we are working in. Now, yesterday we talked about, yesterday, well, in the previous session, we talked about, registration and non-registration, and how people can try to get on record as a conscientious objector when they register. And again, I think as we were talking about earlier, some people, and there are people who feel, that, well, because under US law, a conscientious objector is somebody who is opposed to their participation in war in any form. There are people who feel just registering with Selective Service is a form of participation in more. And so for those, there are some of those folks won't register, and then some of them will register, but will try to get on record as a conscientious objector. And we talked about that in the previous session in some detail of how to do that. But essentially, you would want to, get something. Okay, on the registration card, when somebody registers for the draft, and by the way, the registration card, this is what it looks like. In theory, they're supposed to be at post offices. We know that they're not in reality in a lot of post offices, but there's lots of ways to register with Selective Service. We talked about this the other day. Just applying for a driver's license in many states will get you automatically registered. Applying for financial aid with the FAFSA will automatically get you registered in most cases. And there's might be other forms that if you fill out in the government will somehow get you registered. And so if it's important for somebody to not be registered, they would need to take some, be careful anytime they're filling out any kind of government form, because it could be getting them registered. So read the fine print. But if somebody wants to register and get on file as a conscientious objector, what we recommend is they go to the post office and get this form. And by the way, if your post office doesn't have these forms, and many of them don't, you could go to the Selective Service website, sss.gov, and there is a place on there where you can register online. We don't recommend registering online in this case, but if you scroll to the bottom, there is a place to print out a registration card just like this one. And so if you can't get it at the post office, you could get it on the Selective Service website. Okay. And you could, as you can see here, there's a room. Let's see. Well, here's where they want you to sign. So there is room anywhere up in here. You can just write in here somewhere. I am a conscientious objector to participation in war, or words to that effect. Now, we don't recommend writing it in the margin or on the back. And the reason, by the way, that's a Privacy Act statement on the back. But the reason we don't is because these cards are going to get destroyed. There will be some kind of electronic copy made of them before they're destroyed. But whatever's written in the margin might get lost, and certainly what's written on the back would be lost. So you want to put it between the lines here, or even if there's like it's got an extra space for your address or whatever, just somewhere on there, just find space to write, I am a conscientious objector, or words to that effect. And then you want to also, you want to make a copy of that and keep that copy safe in your records. If you want to try to get it notarized or mail the copy to yourself so you have a postmark on it as a way of verifying a timestamp for when you did this, I mean, you could do that. But it's not that necessary if you follow up with the other things we're going to talk about in a couple of minutes. Okay, but that is one way that some people of conscience can register and feel okay about registering. We have heard testimony very recently from Pentagon officials that they rely on the draft in their war planning. Okay, that is an important part of what they rely on. So we know the draft is thought of as a part of a bellicose foreign policy. And just last month, there was a commission. It's a long story, but there's a commission established a few years ago to study whether women should be included in the draft or whether the draft should be ended entirely. We are really upset to learn that they've decided to recommend keeping the draft and extending it to women. But one of the things that the head of that commission said when testifying before Congress just last month was that that the registration sends a message to our adversaries that we have a national resolve to essentially fight. I mean, that's certainly what he was implying. And so a lot of people of conscience are saying, okay, the law requires that I register, but it's against my conscience to willingly put that out there and say to the world, yeah, I'm willing to fight, because I'm opposed to fighting. And so that's why some people, that's one reason why people don't register, but it's also why some people might choose to try to go through this process to get registered as a conscientious objector. Now, if you fill out this registration card, or get registered, automatically some way, eventually, presumably within a month or so, you will get a registration acknowledgement. And the registration acknowledgement looks something like this. And this is also in your, in your file. This is the Selective Service Form 3. And you see the top of it is a verification of, they basically have all the information they asked you for on the registration card. And then it's also repeated in the section below. And it's basically asking you to, if there's anything incorrect or if anything's changed, you should notify them. And this registration acknowledgement will not in any way acknowledge that you registered as a conscientious objector. So what you could do, what we recommend doing, is on this form here, somewhere down here in the form they want you to send back, right in there, I registered as a conscientious objector. You've apparently made a mistake by not including this in your records, so please correct your records. Now, the Selective Service is not going to do that, okay? But if you send this certified mail, return receipt requested, which the last I checked was about $7 or $8, It's probably going up. Everything in the post office is, but uh, but if you do that and you keep a photocopy, then you will have established proof that that would actually hold up in court if necessary, that you had tried to get on record with Selective Service from the time you registered. Okay, the certified mail return receipt requested means that a postcard gets attached to the outside of the envelope. And as it's being delivered, someone from Selective Service has to sign. And then the letter carrier tears that off and mails it back to you. If you have that signed receipt, it will stand up as proof in court if necessary, as proof that they received something from you on that date. And if they don't have it, it's presumed to be what you say it is. So take your receipt, staple it to your copy. You've got proof you tried to get on record. Okay. And if you registered and didn't know about all this, you could now write a letter of Selective Service saying the same thing, or you could go to the post office. Again, these probably aren't there, but they're supposed to be a change of information form. This change form is supposed to be available at post offices where you could go and get this and mail it into Selective Service, because by law, once people register for the draft, they are also required to notify Selective Service within 10 days if their name or address changes. And according to the Selective Service's own data, almost nobody does that. Okay, very, very few people do that, including people who now work at Selective Service who were required to register at some point during the last, however many years that's been, 30 some years. But that is things that conscientious objectors can do. They can use these forms or just write letters to Selective Service. You want to do it certified mail return receipt, to make sure that that you've got documentation that you tried to get on record. That is not the same as applying for CO status. We talked about that the other day, but I wanted to, but this is a way to get on record from the time you register. We did mention that there's for a lot of people who haven't registered, first of all, you're required to register during a 60-day period that begins 30 days before you turn 18, which technically means that after that, that if you don't register by 29 days after you turn 18, you are in violation of the law. And the vast majority of people affected by the draft are in violation of the law, by the way. And aside from not changing your address, which in itself is almost everybody, but even in terms of the people who have registered, the majority don't register during that 60-day window. And so technically, that's a violation of the law, not registering during that 60-day window. But the practice of Selective Service has been to not prosecute anybody if they register. And their policy has been to give people lots of chances to register. And even, going way back to when they were actively prosecuting people, all the way up until indictment, pretty much, people were given multiple chances to register to avoid prosecution. So it's pretty clear that what Selective Service is really about is getting people to register. But if you don't register, and there are people of conscience who don't, you'll probably get a series of letters from Selective Service telling you that that if you don't register, you could be in trouble, or you're going to lose financial aid, you're going to lose these other opportunities, you could be prosecuted and go to jail. And prosecution, well, nobody's been prosecuted since 1986, okay, and we don't anticipate anybody being prosecuted. I mean, if the draft were to start up again, and at this point we don't see evidence it's going to happen, but one never knows for sure. You can't predict the future. But unless something changes like that, we doubt that there'll be more prosecuted. I mean, there's been millions. Selective Service has turned over millions of names to the Department of Justice for prosecution. and nobody's been prosecuted since 1986. And because this is just not a high priority for them. They got real crime to worry about. Why try to throw people in jail because they didn't fill out a form? So, so there are people, who it's a matter of conscience and importance. They take that stance, and just we encourage them to encourage you as counselors to help them know all these steps they can do to protect themselves as much as possible. And in fact, letters that they get from Selective Service threatening them with possible prosecution simply mean that they've been identified as somebody who didn't register. It does not mean that they're about to be prosecuted. And as I said, nobody's been prosecuted since 1986. And so it is likely that that's not going to change, at least for the foreseeable future. But what does affect people who have not registered are these other, what are called non-judicial penalties. And the one that most people know about is financial aid, especially for college students. You would know this. If you are required to register for the draft and you don't register, you can't get federal financial aid. And that's it's a question on the FAFSA form. Now that's supposedly going to change in July of 2023, but we still have a lot of time that Congress could change its mind about that. But in July of 2023, they're supposed to stop making that a requirement for financial aid, and the question will no longer be on the FAFSA form. But until that time, it will still affect people. And so that is one issue. There's been a number of other issues. You can't get most federal jobs. The official wording is federal executive agencies. And these are what are called bills of attainder. You probably learned this in grade school. Okay, one of the great things about our system is you're presumed innocent until proven guilty, and according to the Constitution, you're not supposed to be prosecuted. You're not supposed to be punished, um, unless you've been found guilty by a jury of your peers or something like that. And these are bills that basically punish you if you can't verify that you complied with the law. And so people are being denied financial aid who haven't been convicted of violating the draft law. In fact, they haven't even been charged with violating the draft law. Okay, they can't get financial aid or federal jobs if they can't prove that they didn't violate the law. So that basically turns our entire legal system on its head. It's what's called a bill of attainder, where a person or group of people are punished without due process. And there was a court case challenging this back in the 1980s. And at that point, everybody affected by, I think it was the financial aid law for college, everybody affected by that law was still under the age of 26. And the court said, well, this law is not intended to punish anybody. It's basically intended to get people to register. And anybody who, you know, wants to get financial aid, all they got to do is register and they can get it. Well, that was true back in the 80s when that court case went to the Supreme Court. That's not true anymore. Okay. The vast majority of people, because once you turn 26, you cannot register anymore. And yet these federal penalties stick with you for life. So there are now millions and millions and millions of men who are permanently barred from getting most federal jobs and getting financial aid to go to college from the government. And so we do believe, I mean, this is a bill of attainder, and we think probably another court challenge might get a different result. But that's where we are right now. These laws do still stand. So at the federal level, I mentioned, it's financial aid for college, and it's most federal jobs, and citizenship for non-citizens. Okay, if you're not a citizen, oh yeah, by the way, non-citizens who live in the U.S. are required to register. I should make that clear. The registration requirement applies to all U.S. citizens, no matter where they live, and all people who live in the United States, all males, regardless of where their citizenship is. There's very few exceptions. People like who are here on a student visa. Okay, you're not really here as a resident. People here who are here as tourists. People who are here as part of the family of a embassy staff, for example. Your father's the ambassador from Peru. You're not required to register if you came here to live with your father. But otherwise, males who live in this country are required to register. And right now, Congress is debating whether to extend that to women as well. So, just keep that in mind. And as you're facing the registration. But people who have come here who have not registered for the draft, who entered the U.S. during a period of time, males who were in the U.S. during a period of time when they should have registered for the draft, then can be barred from getting citizenship. So those are the federal laws. But then there's a lot of state laws that are very similar. Okay, and the one of, I mean, first one we learned about was the number of states saying you can't get financial aid to go to state colleges from the state. There's some states that actually said you can't even, register to go to college in a state-funded school if you haven't registered for the draft. Even if you want to pay your own way, you can't go to a state-funded school for higher education. And then there are some municipalities have passed. There are some states that make that as a requirement for employment with the state. And there are even some municipalities like towns or counties that have added that as a requirement for employment with the town or the county. And then the biggest thing that's happened more recently in the last 20 years or so is linking draft registration with getting a driver's license. And in many, many states, you can't get a driver's license if you haven't registered. And the way that's actually implemented is in many of those states, just applying for your driver's license automatically registers you. So you need to be aware of that. Pennsylvania is not one of those states, but but many states do have that requirement. So these are, some of the we call them extrajudicial penalties. We believe it's illegal, but so far no court has struck it down. So it stands. I mentioned earlier, prosecutions haven't happened in decades. We don't think they're likely to happen. But if somebody were to get a letter from a U.S. attorney, and this would be on Department of Justice letterhead, that might be a sign that there might be starting to move towards prosecutions. We don't think it's going to happen, but just be aware of that if somebody were to get such a letter. And one other thing that I should mention about dealing with folks with law enforcement around this. Okay, first of all, nobody ever has to talk to law enforcement officials if they don't want to. I mean, of course, we know about tactics that people use and that kind of thing, but you're never required to talk to police if you don't want to. However, if you do talk to them, it's illegal for you to lie to them. Now, it's not illegal for them to lie to you, but it is illegal for you to lie to them. So be aware of that as you're dealing with folks. But as a general rule, it's a good rule to basically not talk to law enforcement officials, because anything you say can and probably will be used against you or against someone. And so unless you want to help them take criminal action, take some kind of action against someone, then it's best to just not talk to them. But if you do talk to them, you can't leave. Well, it's against the law to lie to them, and we certainly don't advise that. The other important thing about draft registration that a lot of folks really object to is the fact that it's really a tool for military recruiters. And in fact, the Privacy Act statement that's on the back of the registration card that I showed you earlier, among the things that's on the back there, it tells you that this information will be shared with military recruiters for the purpose of recruitment. So that is an issue for a lot of folks. They don't want to put their name on a list to be contacted by recruiters. Recruiters, once they have your name, they are relentless. You may have had experienced that yourself some. But we've actually at times tried to talk to folks about how do they get a name off of a list of recruiters, and basically the recruiting folks said, well, if we become convinced somebody's dead, then we'll stop pursuing them, but recruiters are relentless, and they do all they can to convince people to join. And that reminds me of something else that is worth talking about while we're talking about this. Um, I would not expect most Quakers to join the military, but you probably have friends who have joined the military at various points, or who have considered joining the military at various points. And almost everybody who joins the military joins through something called the delayed entry program. And it's a program that allows people to sign, like typically recruiters go into high schools, say in October or November, and get people signed up to go to basic training the following summer. And that's called the delayed entry program. They've joined the delayed entry program, and then they're supposed to report to go into the military at some point later, up to a year later. And if people are in the delayed entry program, they can change their mind, and it's real easy to get out. Simply said, they just don't have to go, and that gets them out. But it's important. And one of them, you could maybe really save your friends or acquaintances a lot of stress and hassle just by knowing that and letting them know that if a recruiter has convinced them to, and they sign some paperwork, then they think about it more and they don't feel good about it, they can get out real easy. Even though if they go back to the recruiter will say, oh no, you can't, it's too late, you signed a contract and all that kind of stuff. But the recruiters are lying, okay? And the truth is that if you change your mind, you can get out. And we would encourage you to share that information far and wide, because people need to know that. Because as somebody who counsels a lot of folks in the military, I've talked to a lot of folks who said, look, I knew even before I got here that I'd made a mistake, and the recruiter told me I had to go. And it's like it would have been so much easier for them had they just said, I'm out of here now. So just share that with your friends, because that's important for everyone to know. And they can call our office if they have any questions. It's 202-483-2220. Or you can call the GI Rights hotline, which is 877-447-4487. But we'd be happy to explain that and provide people with regulations if they needed them, and that kind of thing. But the policy is very, very clear. But now we're going to move on to, so we've been talking about things that are happening now, or could be happening now. But the actual how the draft works won't happen until Congress authorizes induction. So before anybody could be drafted, Congress would have to authorize inductions, and then the president would have to act on that authorization and say, yes, we're going to draft people. And like I said, there are two systems that they would then use. And the real difference is in how that selection process is going to happen once Congress authorizes inductions. No matter which system they use, they are going to use a lottery to decide who gets drafted first. And the lottery is basically, they will basically have two barrels, okay? One barrel will have every birth date in the year, and the other barrel will have the numbers 1 through 365 or 366. And they'll just randomly pick out a number and a birth date and assign that number to the birth date, okay? And you get whatever number was assigned to your birth date. Once the draft is in operation, they will hold a new lottery every year for the people who are turning 20 during that upcoming year. And those are the first people who will be drafted. Okay, they call this the age 20 selection group. It's also sometimes called the first priority selection group. But the people who are going to be drafted first if the draft starts, will be those who are turning 20 during the calendar year, which means in January, almost all those folks are going to be 19 years old. Okay, but so, And they will first of all draft all the ones. Whatever birth date gets the number one, they'll draft all those folks. Then they'll go to the number twos, then to the number threes, and so on. Now, they are not likely to get beyond that first year. They never did during the Vietnam period. I don't know, can't imagine they still would in the future, but but if for some reason they drafted everybody in that age 20 group, then they would move to the age 21 group, then the age 22 group, and so on. Now they have regulations that get into all these possible scenarios of various things. I don't know that we need to really get into all that detail, because the important thing is that probably they're not going to get beyond that initial age 20 group. Okay, so if you lose the lottery, if your birthday, if your birth date gets the number 1 or 2 or 3, one of those early numbers, then you will be among the first people drafted, or the first people called up. Now, under the RIMS system, this is the emergency 2-week system that they say they are not going to use, but the regulations support this. Okay, so that's why you need to learn about this. Call day 1 the day Congress authorizes inductions, and the president says, yeah, we're going to draft people. Day 2, they're going to hold a lottery. Day 3, they're going to send out induction orders to report for induction to the people who lose the lottery. And the regulations say that the date you are scheduled to report must be at least 10 days after the date they issue you the order to report for induction. And so 10 days later, 13 days after Congress authorized inductions, the first draftees would report to the MEPS. The MEPS is the Military Entrance Processing Station. That's where people would go now. Like if you were joining the military now and the recruiter got you signed up, you would go to the MEPS to get your physical and swear in and all that kind of stuff. So these offices exist already. And so you would go to the MEPS for the physical examination and moral examination. They'd ask you questions about things. And if they found you acceptable, they would draft you that day and put you on a bus to boot camp. That's how the system is set up to work. Now, if you are a conscientious objector, or if you want to apply for some other deferment or exemption, and we're going to cover what those are in a few minutes, the regulations say that you must file your claim by first of all, the regulations say you cannot file your claim until after they issue an order to report for induction, and you must file your claim by the day before you are scheduled to report for induction. So that you have a very, very small window of time. Now, back in the 80s, when they developed the system, the plan was to send the induction orders by mailgram. But this is an induction order, as they planned to do it back in the 80s. Well, mailgrams don't exist anymore. So presumably it will be, some other kind of fast delivery process, maybe express mail. I'm not sure, because they never updated the old manual, so we don't know exactly what they planned. But it tells you on the induction order, okay, that you've been drafted, and tells you where to report. And then, but on the back, it tells you other things like how to get there and what to bring. And this final paragraph down here at the end is postponement and reclassification information, okay? And here's what it says. You may file a claim for a postponement or reclassification at any time prior to the date you're scheduled to report for induction. Information is available at any selective service area office or through information booklets furnished for registrants at all U.S. post offices, consulates, and embassies. By the way, they are not there. These books are not there. Do not report to the MEPS after you have filed a claim in writing with your area office. So in other words, people are going to get this and have a week or two to respond, and not even know, because there's not a whole lot of information on here about what to do. And so that's part of our concern is there's going to be, if they implement this system, there's going to be widespread chaos. Okay. But according to what's supposed to happen is you're supposed to be able to go to a post office and get a form number 9. This is selective service form number 9, which is the claim form for filing, deferments and exemptions and things like that. And let's see, conscientious objector is right there on the form. Okay, so you'd have to go and get this form and check off the conscientious objector box and send it in. And according to the regulations, this must be done, under this RIMS system. I mean, the RIMS emergency draft system. You must file your claim between the day they issue that induction order and the day before you're scheduled to report for induction. So that's a narrow window of time, because if they're going to give the first people 10 days from the date that's issued, that's not 10 days from the day you get it. That's 10 days from the day they send it. So, and then you're going to lose a day on the other end because it's got to be filed by the day before your scheduled report for induction. So we're talking about maybe a week at best to somehow notify selective service, I'm a conscientious objector. And the regulations are really clear. If you do not act in that narrow window of time, you waive your right to any classification that you would qualify for. So even if you are the most sincere conscientious objection in the country, conscientious objector in the country, if you don't submit your application during that window of time, you waive your right to be able to file a claim. So that's really, really important that counselors make sure folks are aware of this and aware that they need to act quickly. That's also true for any other classification, hardship, or anything like that they want to apply for. Okay, but since we're focused on conscientious objection, it's important to make that claim at that point in time. Now, simply submitting that form, this is all explained in this induction order that they send you, if you understand what it says. But it says, if you submit that form in that time frame, then you don't have to report to the MEPS for the physical to be drafted. They're going to postpone that until after they make a decision on your application for conscientious objector status. And so it's going to be important. So all that stuff we talked about earlier in terms about getting on file when you register for the draft, that's that's background information. That's documentation you can use to help substantiate your claim. That's not the same as filing for conscientious objector status. You must file your claim during that narrow window of time, or it will not be considered. So that's really, really important to make sure folks understand that. Like I say, if you don't submit that form, then you'll be expected to report to the MEPS. And if you pass the physical, they're going to send you to boot camp that day. Okay, so that's the emergency 2-week scenario. Like I said, they claim they're not going to use that system, and they are training the draft boards in the other system, but their regulations support this system, and they've had over 30 years to change their regulations, or about 30 years, 25 or so, and they haven't. So we're not exactly sure what they're going to do in the end. But now we're going to move on to the RIPS system, and this is the system they say they're going to use, but this is not the system supported by the regulations. And according to the RIPS system, rather than those who lose the lottery, well, first of all, there'll be a 6-month period from the time Congress authorizes the draft until they start drafting people. And so there'll be some advanced warning. So people will be able to, think, oh, crap, it might really be happening, So there'll be folks, and both counselors and potential COs and people like that will be having some time to gear up, and as will the draft boards get more serious training, I would hope. And but anyway, Those who lose the lottery, they are going to hold a lottery, like I said before. And those who lose the lottery will not be sent an induction order, but they will be sent an order to report for selective service examination. Okay. And this would be, what is this? SSS form 233. There, it's in the manual. But you'll be sent an order to report for an examination, an examination at the MEPS. And when you go to the MEPS, if you fail the physical, you'll be classified 4F. We'll get to that in a minute. The selective service uses a number letter categories for everybody. But okay, but if you but if you get one of these, you go to the MEPS, and if you flunk the physical, you'll be given basically a medical deferment. But if you pass the physical, then they will tell you that you've been found, you'll be classified 1A, which means available for unrestricted military service. And they will tell you that you have 10 days to apply for a reclassification. And they're supposed to provide you with a form for doing that, which is this form here, which is in your manual. This is Form 8 in the manual. And this is the claim for reclassification under RIPS. And in this one, once again, you'll see conscientious objection is right at the top of the list here. So that's the form that conscientious objectors, and you have to file this within 10 days after you were at the MEPS if you pass the physical. Now, there are some conscientious objectors. I mentioned earlier there are conscientious objectors who objected to registering. And there are some who registered and declared themselves as conscientious objectors at the time they're registered. But at this point, when they get an order to report to the MEPS, which is a military facility, it is the facility where people joining the military go, and again, because they're conscientious objectors, they object to being under military control in any way, shape, or form. So they really object to having to go to this kind of, this physical examination. And the reason I'm bringing this up is because there's another form that people can get that is a request for postponement of the armed forces examination. And if the date that you're scheduled to report, hits on like if you're sick on that day, you can apply to, go at a later day, or you've got a religious holiday, or there's a number of specific reasons that would allow you to delay the date that you go for your MEPS exam. But most importantly, at the bottom of this form is a section for conscientious objectors who object to going to a MEPS for a physical. And this is what it says. As an individual who is conscientiously opposed to both combatant and non-combatant military training and service, I hereby request consideration for conscientious objector status and wish to have my armed forces examination waived until a decision is made on my claim for Class 1O, which is a conscientious objector who does not go into the military and performs alternative service. I understand receiving this waiver. Okay, well, actually, that's wrong. That's changed. Okay, I understand. Okay, that that if any claim. Okay, I understand that if my claim for Class 1O is granted, I will not be given another opportunity to undergo an armed forces examination. Now, that's important because if you're a conscientious objectors, as we've mentioned, are required to perform 2 years of alternative service or non-combatant service in the military. But for people who are applying to be the civilian, to do alternative service, not going to the military at all, they can have this armed forces exam waived. And and that would help them in their conscience. It wouldn't force them to go under military control for an examination. However, what they're doing by submitting this is waiving their right to a medical exemption, okay, or medical deferment. In other words, if you go to the physical and you flunk the physical, you'll be classified, as a medical with a medical deferment, and you won't be drafted, and you won't have to do alternative service. Whereas if you if you pass the physical, so then you would apply for CO status and presumably get approved and do your alternative service. But if you had flunked the physical, you wouldn't have to do service. But in this case, if you waive the physical, you're also waiving your right to get a medical deferment. So even if you would have flunked the physical had you gone to it, and therefore not being required to do any service at all, by waiving the physical, you will not be getting that medical deferment. Okay, you're going to have to you're going to have to do alternative service, even if you would have flunked the physical had you gone. Okay, so that is part of the issue of when we are using the RIPS system, which is the system that they say they're going to use. So after you go to the physical, and so like I say, if you flunk it, you get a medical deferment. If you pass it, you're declared available for unrestricted military service and given 10 days to file a claim. If you don't file a claim in that 10 days, then you will most likely be drafted very shortly thereafter, because we already know your number came up or you wouldn't have been gone to the physical. So people need to be ready to act very quickly and submit that form 8 that I showed you a minute ago to apply for the conscientious objector status. The other thing I should mention is what happens to students, because there's a lot of people. Remember from the Vietnam period, people could stay in school. My uncle got his doctorate that way, just stay in school and you don't get drafted. That's no longer the case, okay? Under the current system, no matter which of these systems they use, if a student is drafted, you'll be allowed to, well, if you're a high school student, you'll be allowed to graduate unless you're still in high school at the age of 20. At that point, they would draft you. A college student would be allowed to finish the term or the semester that they are currently in the middle of. This is a postponement of your being drafted. It's not like a student deferment like we used to get back in the Vietnam era. The one exception to this would be if you are in the final year of your program. If you're a senior, then they would allow you to finish your entire year rather than just the semester. Okay, but then you'd be expected to go. So that is basically how students are dealt with under the draft as it would happen today. So that's basically the two different systems of how the draft works. I think almost everything else is the same for each system, but I wanted to make sure you understood the difference between the two systems. And they say they're not going to use that emergency 2-week system, but they would have to change their regulations if they want to use the system they say they're going to use, and they haven't changed them yet. So just be aware of that issue. So I want to take a little bit of time to talk about the different classifications that are available, because even though conscientious objectors are the primary thing that I know folks are concerned about, if a conscientious objector, like we just talked about a minute ago, has medical issues, they might get a medical exemption deferment and not have to do any service. Similarly, if they had a hardship or if they qualified for some other classification, that would also, prevent them from being drafted. And so we want to at least briefly, go through what those classifications are. Okay, and okay, I'm going to say that if under the RIPS, okay, just to show you this, but this is if the 10 days goes by after the examination under that RIF system, the 6-month system, and you don't apply, or if once you apply for one of these classifications, you ultimately lose and they deny your application, then you are then they send you an order to report for induction, and you would be ordered. And again, there'll be at least 10 days advance notice, but by the time you get it, it might not be a full 10 days. So those are some of the issues. Now, I want to show you, let me see if I can do this. I did a screen share the other day, see if I can do it again. Yeah, okay. Yeah, now this, okay. The selective service classifies everybody with a number letter classification, okay? And actually 1A is at the top of the list, okay? So the top of this list would be 1A, and then immediately under that is 1AO and then 1O, and those are conscientious objectors. And you can see from this list, these are the various classifications that people could get under the law, okay? And according to the regulations, if you qualify for more than one of these things, they're gonna put you in the one that's furthest down on the list, okay? So at the bottom of the list is there's somebody they're not even classifying because they think they're not gonna draft them. And then right above that is the 4F, that's the medical disqualification, but you'll see, but at the top of the list is conscientious objector. And the reason I want to point this out is, according to the selective service, if you qualify for 2 or 3 things on this list, they're going to put you in the lowest thing on the list. Okay, so if you qualify as a conscientious objector, but you're also a student to be a minister, they're going to classify you as a student to be a minister rather than a conscientious objector, or if you have a hardship. And so, so it's important to be aware of this. And except for conscientious objectors, people on this list would not be required to, would not be drafted, to do service. So, so for many conscientious objectors, it's important to at least go through all their options to make sure there's not some other option that might, get them completely out of service if they didn't want to have to do the alternative service. And so that's why I bring this up. This chart actually is in your manual. But like I say, 1A is at the top of the list. So, so if you qualify for anything else, then you should be reclassified out of 1A and classified for that. And so let me just see if I can stop sharing that for the moment and get back on track and talking about what some of these various categories are. Okay, one of them is hardship. And this is a hardship to your dependents. It's not a hardship to you. They understand going to the military is a hardship. Okay, a hardship for your dependents. It could be either for a physical dependency, like, your father's crippled or something like that, and you have to help him up and down the steps and out of the bathtub. It could be for an emotional dependency, like there's a documented, like a separation anxiety or something like that from one of your family members, and you need to be there to care for them or something like that, or to be in their presence for their well-being, or for financial. So it could be for physical, emotional, or financial dependency. As a hardship to your dependents, which are defined as close blood relatives, basically, or spouse. And so, yeah, so you have to show that it's a pretty substantial hardship, and it has to be well documented. But when such a situation exists, folks could get a hardship deferment. And I'd say in terms of the financial hardship, because you think about, well, how many 20-year-olds have a big family that they gotta, that are financially dependent on them. Historically, that was mostly used in the case of like a small family business, like say a small family farm, where the physical presence and labor of all the family members is essential for the financial success. And it'd be like financial ruin for the family if, the strong, young, able-bodied, person in the family were suddenly not there to do the work to keep the farm going. So that'd be an example of that could qualify for the financial hardship. Okay, so hardship would be the first category. The next is ministers and ministerial students. Um, this gets into a weird thing of where the government's trying to determine what is a legitimate church and what is a legitimate minister, and it gets into a gray area. Okay, but but they've defined church. It's interesting because the way they've defined church, and by the way, this, if you look in the manual under the judgmental claim chapter, we get into a lot of detail about what qualifies as a minister, and you'll see they define a church well, as much or more in terms of organization and structure and worship and liturgy and things like this, that as I looked at it, I'm thinking, well, by that definition, Quakers don't qualify as a religion. I mean, I mean, you could argue one way or the other, but I'm just saying that the government is in a strange position of trying to decide, because of separation of church and state, trying to decide what's legitimate church, what's legitimate ministry, and 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 also you've got groups like the Jehovah's Witnesses that claim all of their members are ministers, and and many of them applied for a ministerial exemption, and many of them, well, yeah, it's a long history to that, but basically the rule is you have to be a full-time minister. That has to be your primary occupation. You may or may not be ordained. That's it's not required, but if this is your primary vocation, and that you can document that that's the primary thing that you do with your life, then you could qualify as a minister. And in terms of a ministerial student, you either have to be in a seminary or pre-enrolled in a seminary. Because a lot of seminaries require an undergraduate degree, but you have to be like accepted to go there, even though you're not there yet. And you also have to be officially registered with your church. And again, they get into what is a real church or not, but you have to be registered with your church, and then some official, preparatory status. Like I'm Presbyterian. The Presbyterians call that being a candidate for the ministry, but there's an official process that you go through to get in that status. Okay, and most churches that have clergy have something like that for people who are in the pipeline to become clergy. So you have to be. This is not enough just to go to seminary. You actually have to be in that official preparation stage for your tradition. Okay. The next category is surviving son. And surviving son, um, basically this means that if your mother or father or brother or sister was killed as a result of their military service, then you would be exempt from the draft. You would not be drafted. Used to be that they called it sole surviving son, and you had to be the last male child in your family. So if you had, 3 brothers and one of them was killed, the other 2 could still be drafted. On the other hand, if 2 of them were killed, the third one would not be. I mean, that's how the rule used to be. That is no longer the rule. But because they had this policy called sole surviving son, it caused a lot of folks to erroneously think that if they were the only kid in their family, they would not be drafted. And that is not true. That has never been true. Okay, that was a misunderstanding of this provision. But basically, it has to do with, it's enough for any family to lose one of its members, to the military or war, and they're not going to force other members of that family to go in. So yeah, that's the surviving son provision. Of course, then there's the 4F, which is the medically disqualified. The The military's own studies indicate that about 70% of the people don't meet their physical, moral, and mental standards. Okay, so yeah, it's not just the physical. I mean, that's a part of it, but they don't want people who are convicted of felonies unless the felony is violating the draft law. They'll take you in that case. Um, and they and there's also, you know, educational tests. You have to take some tests to make sure that, and they've actually got ways of trying to check whether you've deliberately screwed up on the test to avoid being drafted. So, I mean, they'll send that through some verification kind of system that I don't fully understand, but you know, but basically when you go to the MEPS, that you will be examined in not just physical, but these other ways. And if they decide that you don't meet the moral standards or the medical standards, then yeah, then they would give you the 4F classification. Those who are in the military won't be drafted. Okay, and that seems a little bit obvious, but it doesn't. I mean, it includes people in ROTC. It includes people in the reserves. You know, so it's not just people who are already in the Army won't be drafted. So, and it includes people going to various military academies or VMI, the Virginia Military Institute, the Citadel, some of these other military schools. They, you know, they would be they would not be drafted. But of course, they presumably are incurring an obligation to go into the military through their schooling, but they won't be drafted. I mentioned that non-citizens who live in the United States are required to register for the draft. And they could be drafted, okay, but there are some exceptions, okay. One is there are if you're a dual national, if you're a US citizen and a citizen of another country, there's a list of countries that if your dual citizenship is with one of those countries, that in itself exempts you, okay? Oh, and by the way, as I'm rushing through all this, I'm not even showing you the forms that I pulled out. Well, I guess don't want to confuse all of that, so I won't get into all that. But the reason, though, the reason I thought of this right now is because there's another category of non-citizen who would be exempted, and that is what's called a treaty alien. And a treaty alien is there's about 15 countries that have treaties with the United States that say you don't draft our folks and we won't draft your folks. And so so if you are a citizen of one of those countries, that in itself exempts you from the US draft. So if you're living in the US, you're required to register, but then if it comes to that point, if you are drafted, then you could apply for the status to avoid being drafted. But there is a catch, okay? Part of what you have to do is submit this form, which is form 130. It's a application for relief from training and service because as a treaty alien. And the law and the regulations say that by submitting this form to avoid being drafted, if you are a citizen of one of those countries, then you will never be allowed to become a US citizen. And if you leave the United States, you will never be allowed to return to the United States as a resident. You could come, I guess, as a tourist or something, but you would not be allowed to return to the United States as a resident. So that is important for folks to be aware of. You know, so their nationality may get them an exemption from the draft, but there might be other consequences further down the line. Some public officials are also exempted from the draft, okay? I mean, the vice president, members of Congress, and essentially members of statewide offices. So, for example, members of the state, like the governor and members of the state legislature, would be exempted. The mayor and members of the city council would not be exempted. Okay, so so there's some public officials, and also judges of a court of record would not be drafted. So, but that pretty much covers the various ways that people could avoid being drafted, other than conscientious objection. And we wanted to make sure folks are aware of this, because if you qualify for one of these things, that might be easier to document, and and easier to get resolved, and would exempt you from having to do alternative service or non-combatant military service. So conscientious objectors, it's important that we go over this with them so that they know what their options are and they're making an informed choice about what they're going to do. So that's basically the various classifications. Now, we talked earlier about conscientious objection, which is one of those classifications. And let's talk a little bit more about it. We talked mostly about it in the previous session, but we should once again cover it briefly. According to U.S. law, a conscientious objector is someone who is, okay, basically the draft law says, nothing contained in this title meaning the draft law, nothing contained in this title shall require any person to be subject to combatant training and service in the armed forces of the United States, who by reason of religious training and belief is conscientiously opposed to participation in war in any form. Okay, so that's basically what the draft law says. So there's really no authority in the draft law to draft a conscientious objector. But but it's the burden of proof is on the person to establish that they have these beliefs. And of course, the big question is, well, how do you prove what you believe? I mean, the standard for getting conscientious objector status is having those beliefs, the belief that it's wrong for you to participate in war. But how do you prove what you believe? I mean, by definition, the belief is something that can't be proven. So that's why, well, the application for conscientious objector status asks basically three questions. What do you believe? How did your beliefs develop? And how do your beliefs influence your life? Or how does your life reflect those beliefs? That's kind of an exercise we did early on in the first session. That was basically based on those three questions that that they're going to be asked of conscientious objectors if they're drafted. And and so although you can't really prove what you believe per se, but by talking about how your beliefs developed, the experiences you have that helped shape your life, that helped shape you into the person that you are now, the more detail you give about how that happened, the more convincing it can be. Somebody who's listening to you could say, yeah, I can see how that affected. I mean, they're probably not going to agree with you, but hopefully they'll be able to say, well, yeah, I can see how if I had had those kind of experiences, maybe I'd have thought that way. That's what you're trying to accomplish with your application is to tell your story about what you believe and how your beliefs came into being in a way that could be convincing to someone who doesn't know you and doesn't know your situation. And so the better job you do at telling your story, the more convincing it's going to be. So, part of it is, whether you have beliefs that qualify under the law. And secondly is, do you really believe them? And so the third question is, how do your beliefs influence your life? And so similarly, when you talk about, you things that you do with your life, that is evidence of the, kinds of values that you have, then, then that also can be convincing that you really believe this. So for example, if you, volunteer at a soup kitchen, or if you, participate in, the, various kinds of things of, like cleaning up the bay or cleaning up the rivers going through town or whatever, because, you're concerned about the environment. um, you know, it can include going to protest marches. It can include things like, the choices of courses you take. If you're a student at one of these Quaker colleges, I'm sure that there's various things about, there's peacemaking that are, offered as, as options for people. And so you say, I chose to take these courses, or, you know, you know, or in this particular course, you know, you know, I chose to do a term paper. I found a way to do a term paper on Gandhi or Martin Luther King or somebody like that, as a way of, responding to, is doing something in my U.S. history course. I did a term paper on Martin Luther King, the civil rights movement, as a way of just showing how, your values influence choices that you make and things that you do with your life. Because, like I say, although on the one hand, the issue is, do your beliefs fit within the definition? But equally important is, do you really believe them? And you got to really convince the board that you really believe this stuff. And so getting back to the definition, okay, I mentioned earlier, I gave a quote out of the law, but you need to know that the key wording is, you must be opposed to participation in war in any form based on religious training and belief. And I did talk about this yesterday, but I'm going to bring it up again. There have been 2 court cases that about this religious training and belief business. And the essence of these court decisions is that ethical and moral beliefs qualify as religious beliefs, and that your religious training is essentially everything that helped shape you into the person that you now are. Okay, so it's not just going to church or going to friends meeting or something like that. It could be, books you've read, people you've met, experiences you've had, and and they might largely be experiences around peace issues, maybe peace and justice issues, but they can be other things as well. Maybe becoming a parent, that certainly affected how I look at life. And I think for most people I've talked to, does becoming a parent changes you. It could be, being in a car accident. Maybe you almost died, or maybe you almost killed somebody. You know, then these things affect you. Accidentally. So think about all the things that help to shape you, people you've known. When I think about it, for me, although I had these values, I was raised, I had good values, having grown up in the church, but I didn't really know anything about conscientious objection. And I remember being in my college dorm one day, and there was a guy sitting in one of the lounges typing up what I thought was a term paper or something, and I said, "Hey, John, what you working on?" And he said, "Oh, it's my CEO application." And it's like, "Oh, really? What's that?" And when he told me, I said, "That's what I believe," but I didn't even know that there was such a thing. So for me, certainly, encountering John that day in the dorm room was a factor in shaping who I am now. But that was just one small thing, you know. I mean, I think for me, a much bigger impact was getting to know students from around the world when I was in college, and coming to, you know, view myself as a citizen of the world rather than a citizen of any particular country. And, you know, and understanding that we're all sisters and brothers, and we all might have different religions and cultures and things like that, but we're all one big human family. And for me, you know, coming to that realization in the depth of my being really has shaped my life ever since then, really. But you know, those were things that I could point to that were important, you know, in terms of shaping me. But but think about what it is for you, for, you know, and encourage your counselees to think about, you know, what it is for them. And keep in mind, it doesn't have to be stuff that you would expect it to be. Okay. Um, I mean, I mean, you know, one of the conscientious objectors. I mean, this probably isn't going to be relevant for those of you facing the draft, but just to give you an example, you know, one of the conscientious objectors I'm working with right now is a woman who's part of the Pennsylvania National Guard. She's African American, and she was called up last summer to help put down the George Floyd protests in Philadelphia, and she was already uncomfortable with her military service and already having questions about the weapons and the violence and things like that. And it was being called up, you know, to that situation where she said, "No, man, I'm on the wrong side here," you know, and that's what really brought things to a head for her, and caused her to realize that everything she does as a part of the National Guard really does. I mean, you know, at its mission, being a military force was against her values. So I mean, so that's probably not going to be so relevant for you, but something that maybe, I mean, one of the things that I can point to that helped shape me, and this is, I know you're going to think this is funny, but you know, I was a Boy Scout when I was young, and I was really active in Boy Scouts, and I one of the things we were taught was that a scout is I still remember this, a friend to all and a brother to every other scout. And I knew that there were Boy Scouts in countries around the world, you know. So even though when I was 13 or 14 learning this stuff, I wasn't making those connections, but later, you know, when I am, you know, really knowing people from around the world and reflecting on things, that was all, you know, those were a part of that values that helped to shape me. And so what we need to do is help folks think about their life, think about their experiences, think about the things that helped to shape them. And sure, some of it might be things they learned in college, or, you know, but it's, or things they learned in church or friends meeting or mosque or synagogue or whatever. But it's not always it's not limited to those things. And, you know, and like I say, books you've read, movies you've seen. Um, yeah. I mean, for me, one of the movies that really moved me was All Quiet on the Western Front, which is a powerful movie and book. I encourage people to read it if you haven't. Um, but just think about, you know, think about the things that have shaped you into the person that you are. Now, the form that people use to apply for conscientious objector status is Form 22. And this is Form 22. It's in the manual. And as you will see, you got these two boxes here where you check off 1O or 1AO. 1O is a conscientious objector who is opposed to participation in the military in any way, shape, or form. And those are the folks who would be drafted to do alternative service. The 1AO is somebody whose objection is to actually killing or being a combatant as a part of the military. And those folks would be drafted into the military as non-combatants. And so the conscientious objector will, submit, will actually check off which of them they're applying for. Okay. And the regulations are pretty clear that, you can't give somebody who applies for 1O a 1O classification as a compromise. Okay. That is not allowed. Okay. So if you make your claim for one or the other, then you have to really, document that aspect of it. And I will tell you that the draft board, will ask, I'm certain they will ask, why couldn't you be a non-combatant in the military? There's plenty of jobs. Not everybody in the military is pulling, shooting guns. Why can't you do a job in the military that's not shooting guns? And in particular, they will often ask about being a medic, which is, and I think we talked about this yesterday about the way the military does triage on the battlefield, is a lot different than the way a person of conscience would be inclined to sort people for medical care. So those are some things, but people really need to think about what they could do in light of their values. And because I know that the military would like to try to force people into the military in a non-combatant way. I mean, the draft boards would like to do that if they could, because that gets another draftee in the military. But but they're going to ask questions about that. So it's going to be important to carefully think through how you feel about those things and be able to articulate how you feel about those things. One of my conscientious objectors now, I think, I'm not even sure if I think I mentioned this in the previous session, she, when she figured out what was going on, and she really was not happy being a part of an overt killing force. And so she switched her job to explosive ordnance destruction or demolition or something like that, but basically diffusing bombs is what she was supposed to be doing, because she thought, well, that way I can still, because she was already in the military, and she was trying to, this was before she even knew about conscientious objection. She was just trying to find a way to, live with herself and still, live with the fact that she was stuck being in the Navy, and she figured out, no, this is not a humanitarian job we're doing. We're clearing minefields so that the infantry can roll through and kill more people. So that's when she decided she really couldn't be a part of it anymore. So it is different for everybody, in terms of what, where they draw the line and where they think they're going to be able to draw the line. But I would really encourage anybody who thinks that they might be able to be the 1AO, which is the conscientious objector in the military doing non-combatant service. I would really encourage anybody who's thinking about that to think about it carefully, because the regulations are really clear that you would never be required to carry or use a weapon or be trained in the use of weapons, but otherwise you'd be a full and regular member of the military, and you could be put on the front lines. And many conscientious objectors were put on the front lines. I think I mentioned the other day the movie Hacksaw Ridge, which was a big movie a year or two ago. That was about a conscientious objector in the military, and he was right on the front lines in the midst of horrendous, bloody battles, but he saved a lot of lives. And that's what that movie was about. And for people who feel they can do that, that's a worthwhile thing, I think. But there's a lot of folks who feel, that being a part of that is really being a part of the military and being a part of a war effort that goes against their values. And the regulations explicitly say, if you are like a part of a vessel, like, if you're stationed on like a battleship, okay, you could be a conscientious objector and stationed on a battleship, and that would be an acceptable job for you, as long as you were not personally involved in the weapons part of it. You know, you could be in the engine room, or you could be, doing something else on the ship. But as long as you were not, explicitly a part of the weaponry, loading the guns, or, shooting them or whatever, that would count as a non-combatant job. And so people need to think carefully about whether that is something they could do. Um, in our experience, most people really do choose to not go in the military once they realize they have that choice. Or people in the military, you know, are almost all of them are seeking discharge. I mean, occasionally we get folks who just want to get reclassified as a non-combatant who are in the military these days, but that really is the exception. And this goes back to what I was saying earlier about respecting them and the choices that they're making. They know where they're at. And we can certainly talk with them and raise questions and help them think about what it is that they want to do. But ultimately, it's about respecting their choice. Okay, but as I said, there's basically 3 questions here. Describe your beliefs. And that's important. The beliefs must fit within that definition. And remember, this is a statement of their personal values and what they can and cannot do as a result of those values. And that's an important distinction, okay? I mean, a lot of first drafts on conscientious objector applications I've seen is a diatribe against war, or, a polemic of, it's, almost an argumentative, essay about how war is bad. And yeah, I would agree war is bad. Okay, but that's not what a CO application is. A CO application is a statement of your values. What do you, how, how do you decide whether something is right or wrong? And for many people, that's a religious faith, but it's not true for everybody. Other people have some other kind of moral framework, but you need to identify, what that is for you in terms of how you decide whether something is right or wrong. And then you need to explain how being a part of war violates those beliefs that you have. And that's the essence of what a conscientious objector application is. And so that's the gist of what people need to address when they answer the question about what do they believe. And then the other 2 questions are more about evidence. How did your beliefs develop? How they influence your life are more oriented towards convincing the person you sincerely believe what you say you believe. Okay. And then you can also get letters of support. And there's a place here for you to list the people who you're having write letters of support for you. And what we recommend, and this is important for counselors, is that the letters of support be sent to the conscientious objector, and the conscientious objector and the counselor go over them together and make sure they really support the application. Sometimes with the best of intentions, people write letters that are not helpful. Okay, for example, okay, say somebody, say somebody, they were in a car accident, and and somebody died or almost died in this car accident, and that just totally shook them to their core and totally reshaped how they view the world. And they are now totally opposed to all violence because they have seen how bad, they've seen some blood and some death, or close to death, and it's really affected them to the core of their being. Whereas prior to that, they hadn't really thought that much about it. And so they are now applying for conscientious objector status. And then a letter of support says, well, I've known Joe since he was 10 years old, and he's always been a peace-loving and, and against war, and he would have never done anything like that. Whereas it's not true. Maybe before this accident, he was not like any, he was, he got in fights, and he was just a normal kid that never thought anything much about this. But then if a letter of support says otherwise, well, that then helps to, lend some discredit to the applicant. So it's important that that the letters all actually support what is said in the application. So that would be important. So then you submit the written application, and according to the regulations, there must be a hearing. Okay, they will schedule the conscientious objector for a personal appearance before the board. And the regulations are very clear that if he does not come to the hearing, that they will rule that he has abandoned his CO application and it will not be considered. Okay, in other words, conscientious objectors must go to a draft board hearing. Now, if they schedule a hearing and it's something you can't do, and you notify them ahead of time and say, look, it's a conflict, or hey, I'm in college, it's 500 miles away, I can't make it this week, but I'll be home next month. I mean, they are supposed to try to work with you to make it reasonable, okay? But it's going to be on the applicant himself. At this point, it's all men working and dealing with the draft, although that could change soon. But it'll be on the CO applicant to affirmatively make sure the board knows I can't make it. The regulations do say that if they fail to come to a scheduled meeting, they have 5 days to submit an explanation, and the board may decide to reschedule the hearing if they think it's a good enough reason. But you really don't want to be in that situation of them deciding whether you have a good reason for having missed it and reschedule. You want to be ahead of the curve here. You want to, before you're even in that situation, let them know, look, that's not going to work for me. Let's try to find a different time that we can come. The board is supposed to try to work with you and be reasonable, but how that will play out, nobody knows. And that's a case where the counselor might make a difference if they're in touch with the board and say, this is clearly arbitrary if you're insisting somebody travel this distance, on virtually no notice, or you're going to claim he can't qualify for conscientious objector status. I mean, no, that's not at all legitimate or reasonable. And so we may have to do some of that kind of advocacy. Hopefully, we won't have to do too much of it, but those kinds of things could be a problem. So the personal appearance is required. We would recommend, first of all, I think the counselor should would do like role plays with the person, or even organize mock draft board hearings where the potential conscientious objector, would sit in front of a panel of people who would then ask him questions about his beliefs and about his application, and even ask some hard questions to try to trip him up as a way of trying to get him ready for the CEO hearing that they're gonna have with the draft board. I think I mentioned before my draft board. Because I wrote my application in my Christian beliefs, my draft board knew all sorts of quotes out of the Bible that would seem to support war that they threw at me, and I mean, I think I handled them pretty well, but it's really not fair to have somebody who's like, well, I was 20 at the time, but so yeah, so somebody who's 20, that's probably who the age they're going to be, or certainly a lot of them are going to be, to have somebody who's 20 years old, in front of a panel of at least 3, probably more, older people who apparently don't agree with their position, asking them, all sorts of questions, and potentially hostile questions, but whether it's hostile or not, they may be difficult questions. And so so the person really needs to think through some of those things. I mean, my draft board, like I said, they asked me about they threw Bible quotes at me. I still remember one of them was, didn't Jesus say render unto Caesar the things that are Caesar's, to somehow suggest that the government says I should go to war, I should go to war, you know? And of course, my response to that was, yeah, but the other half of that is render to God what is God's. And, and life is God's. And the government doesn't have any authority to, tell me that I should take somebody's life. I mean, I remember that was one of the things I remember from my draft board. And one of the other things I very much remember was that they asked me, well, what are you going to do if we turn you down and we draft you? And I basically told them, I said, well, I mean, what I said at the time, which is, I believed this at the time, well, I know I can't go in the Army. I don't think it's responsible to leave the country, so I guess that means I'll go to jail. I mean, I said something like that to my draft board, and then got hit with the prospect. Geez, I might go to jail because of my beliefs. And I mean, I now know that probably wouldn't have happened. Okay, but I also and I also feel differently about leaving the country now than I did back then. But that was an honest answer for me at that point in time. And so, but people need to be prepared for, whatever it's going to be. So you as counselors need to be talking with your conscientious objectors, get to know them, ask them questions, ask them hard questions, help them be ready, for the hearing. Now, when they go to the hearing, they have the right to an advisor, so you can go with them. You can't really act like a lawyer or anything like that. Your role would be to consult with the conscientious objector during the hearing. Draft boards, I mean, and part of the training that we've seen, I mean, if a conscientious objector is talking to you, their counselor, before they answer every question, then it's going to look to the draft board like you're feeding them answers. So you don't really want to have that. I mean, I think it's important for you as a counselor to be there and to be supportive, and when necessary, consult with them. But it's best to sit back and let the CO, respond on their own as much as possible, and only jump in to talk to them when it seems clear that they need a break or they need some kind of support, because you don't want them, because like I say, it's what they believe that's important. And if the draft board thinks they're just mimicking what you tell them, then that's going to undermine their sincerity. So you need to be careful about how you relate to them during the hearing. But before the hearing, you can go all out in terms of interaction and asking questions and challenging them, because all of that will help them to do a better job once they get to that point. So let's see. Okay, also, it's going to be important to count how many draft board members are present, because only board members who are present for the hearing are allowed to vote on the classification. And when you get your classification, it should tell you what the vote was, so that you can make sure it's the right number of people, okay, that voted. And if the draft board turns the person down, we'll get to that in a minute. Okay, you're not allowed to. Okay, at the hearing, okay, you can take an advisor. You can take up to 3 witnesses. So the kind of people you had write letters of support, you could take them to testify on your behalf. I took my mother and my minister and a man from my church who had been a conscientious objector in World War II. That's who I took to my hearing. But look around. If your students at one of these colleges, you might have a professor that you're really related to that would be really helpful and good to be with your hearing. So, but just you do have the right to have witnesses. These are people who can testify on your behalf, testify to your sincerity, your integrity, maybe talk about things that you've done that are consistent or evidence that you sincerely believe these things, things like that. The hearing can be open to the public upon the request of the applicant. And that's actually a good thing to request, because for a couple of reasons. One is you could get other people in the room that could be supportive, and also potentially, if there's other people who are going to be going before that draft board who are conscientious objectors, if you're a counselor, you can get some of them into as part of the public so they can get a firsthand look at what the CO hearing is like, so that that'll help prepare them better for when they go before the draft board. So those are some things that are worthwhile. Now the draft board can close it to the public. Okay, the draft board can put limits based on the physical space. If you don't have a big enough room, if you don't have a big room, you can't bring in 50 people. Okay, but so they can put reasonable limits on it for that reason. And if they become disruptive, they can close the hearing. So if everybody comes in there and starts doing some kind of anti-war chant or something like that, the draft board will say, okay, you all have to leave. Okay, but as long as they're just sitting there watching, maybe taking notes, there should be no reason for the draft board to exclude the outside, the public from witnessing what's going on. And also they can ask the advisor, the advisor, to leave if you become disruptive. Okay, but as long as you're doing what I talked about a few minutes ago, on occasion consulting with your applicant when necessary, and otherwise just letting things go along as they go, there should be no legitimate reason for them to have you leave. Okay, but if you are, but yeah, if you become disruptive, one of their simulations for the draft board has, for the draft board trainings, had like an advisor who was a lawyer who kept objecting to the questions and advising the client not to answer and stuff like that. Well, of course the draft board's gonna tell the guy to leave. Okay, so but as long as you're not doing those kinds of things, there's every reason to think that you should be able to stay through the hearing and be supportive of your conscientious objector that you're helping. And yeah, so now there cannot be a recording or a verbatim transcript of the hearing. That's in the regulations. We don't know why. We've objected to this, but that is what the regs say. And so the what we recommend is that as soon as the hearing is over, that the CO applicant and possibly some of the witnesses, write up a very detailed description of what happened at the hearing. And one way that might be effective would be to leave a recorder in the car, and as soon as you leave the hearing, start talking into the recorder, giving as close to a word for word description of what happened, in the hearing, and then you can transcribe it, and you could, write it right then, and within a couple of days, submit it to the draft board, and with a cover letter that says something like, attached is my my record of what happened at the hearing. It is true to the best of my knowledge and belief. Is accurate, but if anything is incorrect, based on your memory, please notify me, as soon as possible or within 10 days or something like that. And they'll probably never even look at it. They'll probably just stick it in your file. Okay, but it'll be part of the record. And if at some later point it ends up in a court or something like that, and you get some draft board member saying, no, well, that's not what happened. And it's like, well, why didn't you say something back then? Your memory now, a year or two later, is not going to be considered as accurate as something that was written at the time, and you were given a chance to respond if it was not correct. So those are some things that we recommend people do, and you as counselors can help the applicant, uh, you know, write this up and get it submitted in a timely manner. Now, if they approve you, you go into alternative service or non-combatant military service. We'll get back to that in a minute. But if they turn you down, you have the right to appeal. I believe you have only 15 days to submit an appeal. And by the way, when they after the hearing, they will actually this form here. It's a selective service form number 110 is the notice of classification. And so so here you can see this is actually the form that people can use, and you will notice at the bottom here it says request for an appeal. Okay, right there. So you can request an appeal using this form, but you don't have to use this form. Okay, the regulations actually say that any correspondence should be liberally construed to allow for an appeal. Okay, that's actually in the selective service regulations. So you could just basically write "I appeal" on a piece of paper, make sure you sign it, put your selective service number on there so that you're properly identified, and submitting that, and that should be adequate to allow for an appeal. And if you appeal, it would go to a district appeal board, and all the rules of the district appeal board are the same as the local board level, except that you will not be allowed to bring witnesses, to people to testify on your behalf. But you can still have it open to the public. You can still have an advisor. And then if your CO application is turned down by the appeal board, if it's a unanimous decision, then you have no further appeals within the system. But if just one person votes in your favor, then you can appeal to the National Appeal Board, and and the rules there are the same, except that it's the final, as at the appeal board, except that it's the final formal appeal. It's possible to do informal appeals, try to talk to the director of selective service or the state director, have them intervene. The national director of selective service does have the authority to classify people under the regulations. So there are some informal things that you as a counselor may be able to do. And actually, if the draft gets activated, it might be good for you to try to get to know members of the draft board, so that you'll know how to maybe reach out to them, or certainly get to know, the people in the area office, or the state director for your state, because talking to them will sometimes make a difference. Okay, I mean, our office is on a first name basis with the national office staff, and even though they don't always agree with us, I do think they have some respect for us, because they respect how long we've been involved with this, and how well we know this work. Actually, I think we know it better than they do sometimes. So so that'd be worth doing for you as counselors. Now, obviously, if your application is turned down, you have to figure out, what are you going to do? And for many people, I mean, well, for conscientious objectors, going into the military really isn't an option. And I mean, I think I mentioned this yesterday. Refusing induction is an option for people, as a violation of the law. And then it goes into the courts. But remember that on the one hand, it's up to the conscientious objector to establish that they are a conscientious objector with their application and their documentation. But the draft law says there's no authority to draft a conscientious objector. And so for somebody whose claim is, draft somebody into the military, into combatant service. And so for somebody who whose claim is turned down and they refuse induction, if the government's going to prosecute them, the government has to prove that the draft board did the proper thing by turning them down. And that if the applicant did a good job, and if it's pretty clear that the draft board was wrong in that decision, well, usually the government's not even going to prosecute, because they're going to look at that and say, well, we're going to lose that case because, that was not a valid induction order because the draft board didn't do their job properly. And we can't tell what the future holds, but in the past, conscientious objectors in this situation, most of them who refused induction were not prosecuted. That was the last they heard from Selective Service, because it was clear that the Selective Service system had not acted properly on their application, or there might be other reasons why people weren't prosecuted, but most of them were not prosecuted. Okay, and in the almost half that were prosecuted, the government lost 90% of those cases because the defense was able to show that this is a conscientious objector who should not have been drafted, and if the draft board had done its job properly, this wouldn't have been an issue. And so we don't know what the future holds, but we know that's what happened in the past, and we would hope that we would have similar kind of results in the future. Okay, but I guess, well, actually, we would hope there's no draft, but if there is a draft, we would hope it would be those kinds of results. But for then people who do get approved, okay, the non-combatant, people who get approved for the 1AO status, which is the non-combatant service in the military, they would be drafted into the military, and they would be expected to perform 2 years of service in the military in a non-combatant role. And like I said, doesn't mean they wouldn't be on the front lines. They often were. But there are people who take that stance. I mean, their stance is something like, well, I believe I believe I should obey the government unless the government tells me to explicitly do something immoral or wrong, which would be killing people. But short of killing people, I can do what the government wants me to do. I mean, I think that might be, part of the framework of how people, walk that line. I don't know. It's not what I believe, so I'm not good at articulating what they believe. But it's important that we support them in their choices, and help them understand that they're going to be in a difficult situation. There's lots of documentation of the chain of command not honoring the non-combatant status, and things like that. So life in the military for non-combatants can be quite difficult. Now, in terms of the civilian alternative service, which is a much which is where most people are at, okay, who are conscientious objectors. I think I mentioned this yesterday, but I want to review this because it's important. The wording in the law is you must perform your alternative service must be work in the national health, safety, and interest. Okay, that's what the law says. The regulations have specified 5 areas of work that are appropriate for conscientious objectors: agriculture, education, healthcare, environmental protection, and social and community services. And so if you were to get a job that's in one of those fields that is in a not-for-profit kind of setting, then that should qualify as alternative service. And what's really good is the regulations actually allow for you to choose your own job. If you find a job that meets the legal definition and the employer wants to hire you as a conscientious objector to do that job, according to the regulations, that's the priority for where you get assigned, which is a big improvement over the way it was in the past, where the military, where the draft boards are trying to arbitrarily assign you places, and in many cases try to make your life difficult. And so, so once somebody is recognized as a conscientious objector, um, for a 1-0 conscientious objector, they would receive an order to report for alternative service, which is this. And it would basically tell you that in the near future, you're going to get a job. You're going to be directed to come to a job counseling session. And then they, and this is actually, and that, by the way, that, so yeah, in terms of forms in the book, that's form, the order to report for alternative services, selective service form 155, and form 159 is the form ordering you to report to a job counseling session. And basically the regulations say that, what the normal process would be if you don't find a job on your own, and they want this placement to happen quickly within a matter of weeks after you are classified as a CO. It's not going to drag on for months. And but one of the things they're going to do right away is have you submit what's called a skills questionnaire. Okay, because the idea is they want to get you matched to a job that has, the first priority would be a job you find yourself, if you can find a job yourself. But the second priority would be a job that they have that most closely matches your skills and interests. Okay, and so this is it's in the manual. It's form 156, but this is the skills questionnaire where you can, it asks you all sorts of questions on here about, what you like and what kind of training you've had. Like, yeah, it really goes into quite a bit of detail. But on the 4th page of it is proposed job. You see that? So, so you can actually propose your own job right there. And you should know that selective service has entered into agreements with various potential employers. Even now, they've got, what do they call them? MOUs, memorandums of understanding, with various agencies that they hope are going to hire conscientious objectors if it ever comes to that. But once things get activated, the employers will fill out a similar form. Okay, so that job question, like that form for the CO asks, and this is actually now form number 157. Okay, but that form we just looked at asked the conscientious objector about their skills and their training and their interests. And this is the comparable thing, from the employer describing the job and the kinds of skills that they are looking for in a potential conscientious objector. Okay, and so these forms would be on file with selective service already from employers, and selective service would then, if you didn't pick your own job, they would do a computer matchup to try to find a job that is best suited for you. And if they can't find such a job, then they'll just assign you wherever. But according to the regulations, the priority is getting you into a job that that does meet your your interest and your skills. And the regulations say that overseas placement is possible, provided that the employer is based in the United States and that the employer can satisfy selective service that they can adequately supervise you in your overseas assignment. And this has been really an important part of alternative service over the years. There were a number of people who performed their alternative service in Southeast Asia during the war in Vietnam. They were actually in Vietnam, but totally civilian and not a part of the war effort at all, working with, children in schools and, and things like that. And so, so those kinds of things are possible. Those things were usually done through church agencies like the Mennonite Church or something like that. But but there was a lot of folks who did serve in other countries over the years. And so this form number 160 is the request for a placement overseas. So a conscientious objector who did want to work overseas, that has an option. Now, typically, selective service, once you're drafted and assigned to a job, will provide transportation to wherever it is they assign you to. However, if you do an overseas assignment, they will not provide transportation to your overseas assignment. Now, if people develop a hardship, like we talked earlier about a hardship deferment for for people who might be in a situation where they have a family hardship. Okay, well, if you didn't apply for that and you never had that kind of problem, but then once you're doing your alternative service, which goes on for 2 years, something does happen. Maybe your father has a stroke and now he's crippled and you have to care for him or something like that. Well, then you can apply for a hardship if you're doing your alternative service. And here's a form for that. That's form 167. Okay, but the thing is that you would not then get the hardship deferment. What you would get is a hardship postponement, that you would be relieved from having to do your alternative service during this hardship situation. But if this hardship situation ends before you turn 26, because once you turn 26, you're normally no longer subject to the draft. Okay, so if the hardship situation ends before you turn 26, then you would have to then return to finish your alternative service. But if you get too old for the draft and the hardship is still going on, then you would not have to finish your service. So that is one option. And the other thing is, if you get assigned to a job that violates your religious beliefs, like or your ethical or moral beliefs, the beliefs that are the basis of your conscientious objector application. If you get assigned to such a job, then you can appeal that placement. And there would be an appeal board that you could, basically selective service appeal board would hear that appeal. And, but, so they would, but the real standard for this would be that, the regulations actually say something like, excuse me, you have to show how your conscience would be disturbed by doing this job in the same way as participation in war would be, would disturb your conscience, would be an offense to your conscience. So it's going to have to be pretty significant to, appeal a job placement. But if people were somehow assigned to a job that really was offensive to them and their values, there is that option to appeal that job placement. And here's a selective service form 168, which is a form about the appeal board's giving its decision about about whether you're going to get reassigned. And I guess there's other grounds for reassignment as well. For example, maybe the employer maybe the employer goes out of business or ceases to exist, or possibly the job that you're doing, the employer no longer needs to be done. And they will notify selective service and you would get reassigned. Or there's also the possibility of reassignment if you're just not doing the job. And that's a part of it, is the employer has to agree that they will report to selective service and ensure that you are adequately performing your job. So if you're not adequately performing your job, selective service would reassign you, or could potentially, I guess, bring charges against you for violating the draft law for not performing your duty as you should. But I think the first step would be to try to get you into a job where you could perform well. But there is but here is the form for reporting a suspected violator. This would be Selective Service Form 301. But yeah, this is actually the form Selective Service would use to report somebody that is violating the draft law from their perspective, and then they could potentially go into the courts. Now, the other thing I should mention is for you as counselors, I think we're actually almost finished with what we're going to cover today, is that you may encounter or know of groups or agencies that would be willing to employ conscientious objectors. In fact, I wouldn't be surprised if Swarthmore or Haverford or Bryn Mawr themselves wanted to hire some conscientious objectors for some jobs. And so, there or agencies or groups that are going to hire conscientious objectors for alternative service must enter into an agreement with Selective Service that they will supervise the person, report properly, and things like that. And so this is form 152, I think it is, in the manual. And here's an example of the form that such agencies could fill out in terms of agreeing to provide the kind of supervision and support for conscientious objectors. COs doing alternative service are paid by the agency they work for. And the regulations say that they would normally be paid a comparable wage to other people performing the same job, and they would be expected, to meet similar kind of standards of performance and conduct. And so the Selective Service employer has to submit reports periodically. And here's an employer data sheet, be one of those things that like I say, an employer is going to have various forms they have to fill out with Selective Service. But if you know of agencies or groups that might be, wanting to, to hire conscientious objectors, well, I know these days Selective Service is looking for agencies to sign memorandums of understanding with. We're not necessarily recommending that you do that. Okay. In fact, we kind of think that's kind of a silly thing to do because there's no real draft now and there's nothing really going on. And it seems to us that, being able to say that they are reaching out to groups to sign these memorandums of understanding is one of the ways that Selective Service can justify its existence. It's like, oh yeah, we're doing worthwhile work here. We're trying to line up, conscientious objector jobs for people. So we're not necessarily saying anybody should reach out to Selective Service now about such an arrangement. But if the draft were to resume, then you do have, then I would say it would be important for groups that would be willing to hire alternative service workers to do that. Wow. I think we've covered most of what I needed to cover today, I think. I'm sure that you all are going to have more questions, and I'm looking forward to talking with you on Saturday and answering any questions you might have and helping you, fill in whatever gaps in knowledge you might still have based on all of this. And I know this is a lot to take in. I'm actually getting tired of talking right now. So, but, maybe, hopefully you'll be able to absorb it all. And you can look at the manual that you have that explains a lot of this in even more detail, I think. And, but I just wanted you to understand this is really, really important work, and working with conscientious objectors is such a joy, as I'm sure you may already know. And so yeah, I want to encourage you all to get engaged and talk to folks about these things, because I think it's important uh, that we always do all we can to support people of conscience who are taking the stance. We haven't talked about. I mean, in the previous session, I mentioned some of the other ways that people of conscience uh, take their stance. And of course, one of the big ones has been regarding paying for war. And there have been a number of folks who have either refused to pay their taxes or who consciously lived under the taxable level so they don't have to pay for war. Some have brought various court cases trying to challenge the being forced to pay for war as a violation of their religious beliefs. I mean, there's been a number of ways that people have and continue to take a stance against war, and and I know our work, we feel blessed because we're talking to a lot of folks who are in the military who are taking that stance in a time and in a location where it's there could be some serious consequences, and it could be really, really difficult for them. Okay, so I want to encourage you to be as supportive of these folks as you can be, and reach out to us with any questions you might have. Not just on Saturday, but if next week or next month or next year, a student comes to you with some questions, and you're thinking, I'm not sure what to do. Call us. This is what we're here for, and we'll be glad to do all we can to be supportive of you and of all people of conscience. And thank you for your attention on all of this. And I look forward to talking with you on Saturday. All right. Take care.